everyone. Thank you for joining today's webinar, What the CAFC's Recent 101 Decisions Mean for Software and Wireless Devices. I am Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to welcome you to today's event. A few things before I introduce today's presenter. First, please submit any questions during the webinar by using the Questions tab in your console. Also, you can download a copy of today's slides in the Handouts tab, and a link to the recording from today's presentation will soon be sent to you. We're happy to bring this webinar to you in partnership with IPWatchdog.com, and I'd like to introduce our moderator, Gene Quinn. Gene is a U.S. patent attorney, the founder of IPWatchdog.com, and a top 300 IP strategist. He has been recognized by IAM Magazine as one of the top IP strategists in the world. Regarded as an expert on software patentability and U.S. patent procedure, he regularly advises attorneys and clients on patent matters, litigation strategy, and appeals. And with that, I'd like to turn it over to you, Gene, to introduce today's other panelists.
Okay, thank you, Gail. And thank you, everyone, for joining us here today and taking a portion of your time here to talk about 101 issues with us here today. Before I get started and introduce the other panelists, what I'd like to do is I'd like to take a moment to thank LexisNexis IP for being a sponsor for this webinar series and for being a sponsor of IP Watchdog for quite some time now a number of years, and they make it possible to bring this webinar series to you for free. So like I always do, I'd appreciate it if you find yourself in need of any of the services that LexisNexis IP offers, if you could give them a test drive, I would appreciate it, because they make everything that we do here at IP Watchdog possible. They have Patent Advisor and Patent Optimizer, and of course a whole suite of tools and books. And one of the things that is particularly interesting that is making a lot of people's lives easier is this pre-populated response document that gives you a starting point with respect to filing responses to office actions. It makes it easier, it streamlines the process. So give it a try, see if you like it. In a world where clients are continuing to ask us to do more and more for less and less, LexisNexis IP has an awful lot of tools that can really streamline the process. So please do check them out. Thank you to LexisNexis. So let me introduce our panelists here today. First is Bob Stoll, who is co-chair of the Drinker-Biddle IP Group, and he is former commissioner for patents. He spent 34 years in the government, and he was instrumental in working with the passage and then implementation of the regulations that became the American Invents Act regulations at the patent office. And he's been with Drinker-Biddle for a number of years, and he represents clients on a variety of different patent issues. Thank you for being here, Bob.
Thank you.
Also joining us is David Hall, who's a partner with Sage Patent Group, and David has been an attorney since 1993, and he has a particular focus on patent preparation and prosecution in the electrical and computer space, and he previously served as Associate General Counsel for IP at Cree, and David's firm, the Sage Patent Group, was recently identified as having the highest allowance rate in the country for cases including rejection under 101, and their allowance rate has been over 97% when facing a 101 rejection. So we have a couple experts here on 101, and that's good because frankly, you know, in the ready room leading into this conversation, I was sharing with both David and Bob, I really almost don't know what to say anymore. We're going to talk about the problem here. We're going to hopefully give some takeaways and some ideas, but the cases that have come out this summer, if you haven't been paying attention, have really kind of made me scratch my head and wonder where we really are. So gentlemen, before we get going and talk about these cases and then hopefully try and provide some guidance on what attorneys and clients need to be doing, let's pause here. This is the agenda text. We don't need to necessarily go through it. Everybody has presumably seen it when they've registered. But Bob, I'll start with you, and David, I'm going to ask you the same question. as we start this substantive discussion on 101, and I guess this is really the state of 101 in light of these recent Federal Circuit developments, what is it that you want people to have in mind, Bob?
Um, I, I want them not to give up hope. Um, I I have been very troubled by some of the recent decisions. I think that 101 is getting much more confusing instead of clearer. I applaud Director Yanku's guidelines, but the courts seem not ready to accept them yet. These recent cases are terrible, but I do believe that with all of the discussions on the Hill, 45 different people testifying on 101 alone. That's unheard of. And with the continued publication and announcement of the problems that the interpretation of 101 is causing, we will start to see the courts move in the correct direction. I believe that will start to happen. Maybe it'll be spurred on by introduction of legislation or further discussions in mainstream media. But I believe the courts are going to be the ones that I'm ultimately going to have to turn to fix it, because I don't see legislation passing, and I think that things have been getting more and more confusing instead of less confusing.
Okay, we're going to come back to all of that stuff. There's a lot to unpack there over the next hour. But David, your preliminary thoughts. I know your firm has been very successful at getting patents allowed here, but these recent developments have really made me scratch my head. I mean, what do you want people to think about as we enter this substantive talk?
Well, I guess, I'd echo Bob a little bit, and that's just don't give up hope. I think there is still room for successfully prosecuting applications in this space and getting them through the PTO and getting them, through review by the courts. I'll be talking about some of the more practical things that we might think about doing, even in view of these cases. And I think if I had one key takeaway from sort of what I've read from these cases and our experience, is that when you're writing your claims, to focus on that prong 2 of step 2A of the Alice Mayo analysis, whether your claims, to the extent they recite an abstract idea, whether that abstract idea is integrated into a practical application. That's really where you want to focus your attention on when you're drafting. You want to draft those claims in a way that lets you avoid ever having to even get to step 2B. And we can talk about some of that, more about why that is. And to really understand, when you're looking at whether it's integrated into a practical application, to really understand the difference between implementation and application. The courts disparage implementation, but they bless application. And so those are the things I want people to be thinking about.
Okay, that's great advice. So now let's kick this off, and I'm going to race through the first few slides here, which are likely just laying the groundwork. What everybody knows, this is the 101 slide. It has the text there. Whoever invents or discovers any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof may obtain a patent therefor, subject to the conditions and requirements of the title. So remember, in 1952, the legislative history said anything made by man under the sun is patent eligible, but the Supreme Court has had these 3 judicial exceptions related to laws of nature, natural phenomenon, and abstract ideas. After the 4 cases that the Supreme Court took over the last 10 years on patent eligibility, we're left with the Aliceman Framework, which is illustrated by this flow chart, which is taken from the MPEP. And the first step is the statutory question. And then the second step, step 2A, is in patent office terms, is the claim directed to one of those 3 judicial exceptions? If no, then it's eligible. If yes, you go to step 2B, which the next claim asks, does the claim add significantly more, such that you're not merely claiming the judicial exception? This has been characterized as the hunt for the innovative concept. What I just said is all written down here in text. It's the Alice Mayo basics. And then we have here a select list of precedential cases from the Federal Circuit. Now, we're not going to go all the way back to all of these, although I suspect a number of these will come up in our discussion, and I suspect a number of these will also come up in your questions. We're going to primarily focus on the last two, the Sola Tran versus Elevon and the Chamberlain Group case, which were decided this summer. Now, the reason that I wanted to do this particular webinar, and I'm glad that LexisNexis allowed me to do this when I pitched this topic to them, was because of this quote in the Sola Tran case when I read it, written by Judge Chen. We've previously explained that merely reciting an abstract idea by itself in a claim, even if that idea is novel and non-obvious, is not enough to save it from ineligibility. Now, I find it impossible to understand how that can be the case. Now, I suppose that if what we're talking about is an idea that is really an idea in the copyright sense, then that's probably okay. But that's not the type of idea that what we're seeing when we're looking at these cases. The ideas that are being determined to be abstract are really concrete. And in this Sola Tran case, they even talked about no amount of physicality will save a claim from being abstract, which again is very difficult to swallow. So I just don't understand how any of this really fits together, and it's very frustrating. So now before we get any further, let's put some meat on these bones. And David, you asked me to specifically put the claims into the PowerPoint slide, which I think was a great idea here, particularly for the Sola Tran case. And I get to element 1A, electronically receiving a data file. And I stop reading there and I think to myself, how is that abstract? A data file actually exists. I mean, what's going on here? Do you have any thoughts?
A couple of thoughts. One is, we've seen with these decisions that the courts are not hesitant to just wholesale throw out parts of the claim that they think are not really related to what they consider to be the inventive concept. And even if you've got lots of structure in your claim and lots of physicality in the claim, the courts are disregarding a lot of that as just mere implementation details. And they basically treat it as window dressing and say, we're just going to disregard that. And I think they did that in the Sola Tran case. I'd like to parse out some things from this claim at some point, but when we talk about some of the takeaways in here, but I think there's even an express statement in Sola Tran. One of the overarching problems here is, and I hate to Monday morning quarterback something that was written 10 years ago, but the court really sounded like it was just offended at what it viewed as the breadth of the claim. And it spent the whole opinion trying to justify why it was throwing out a claim that it just felt was just too broad. And I can point you to the sentence in the decision. It said, to the contrary, the claims are written at a distinctly high level of generality. And I think that's a really important statement in that case, because it gives you an idea of where the court really started from. And where it started from was based on the claim language. And when you look at it and read through the claim, it does appear to be, it has a level of breadth to it. And I think that's because of the way they drafted the individual elements of those claims. And that's something I'll talk about when we get into what does it mean to tie the inventive concept to the application.
I think you're being very kind to the court.
Yeah.
I think that's and because you can see my name as one of the
I was going to wonder
decided
whether you were
it,
going to say
I'm
that.
a little
So
reluctant to get too much into it, but I think it's a terrible decision.
So
And
hold on, let me. That's not actually your name, right?
No, it's not. It's my sister-in-law, Judge Caristol, who
Okay.
was one of the panel here. Kara, I love you anyway, but I think it's a terrible decision. The judges are, are required to take all of the claim in its totality, not to parse it, not to take a thing. And it does have specific hard features to this claim. Electronically receiving. I'm with you, Gene. That's it. David, if they want to get it on breath, maybe they can go under 112. This should not be thrown out under 101. This is ridiculous.
See, and you know, that's the thing. And when I flipped ahead to the next slide, which has this sort of my summary in one slide of, you know, a long decision, not, you know, it's not like it's a con law decision or an antitrust decision, but this is, I was looking to see if I had that quote that you mentioned, David, because I did notice when I was summarizing the Chamberlain case, they said the same thing. It was clearly concern about the breadth of the claim and the fact that in that case they said it was not focused on any kind of implementation, I think was the wording.
Well, and I agree with them in the Chamberlain. I have lots of other problems with the Chamberlain, but on that one I kind of agree with them. So we can talk about that.
Well, I mean, let's talk about this one a little bit more, because I think the problem that I have, and Bob, I think you and I have the same problem, is these things should not be going away on 101. They unfortunately are going away on 101. And that is the reality. And this is why the legislation is so important. And actually, it's not just the 101 legislation that's important. It's the Stronger Act that's important as well. I mean, because I think it's the Stronger Act, isn't it? Or one of them says you have to look at the claim language in its totality. And this is something that the PTAB has done repeatedly, where they'll look at language from the claim and they'll take it all out. They'll take all the tangible stuff out, particularly on the CBM stuff. And then they'll say, well, once we take out all the tangible stuff, there's nothing there to hold it even together. It doesn't even make sense. And this dissecting of claims is a real problem. And you have to be aware that it's going on, even though we don't like it. So I guess two thoughts. One, Bob, can you talk a little bit about what's going on legislatively and why people need to get involved if they're not involved? And then David, I'd like you to talk about, well, what do you do? Bob?
Well, I think that there's a lot of frustration with both the IP community and the Hill on 101 issues. There are still discussions going on. I understand that they're going to be revamped up this fall because there have been people who have been seeing from the Hill new permutations of the 101, some of it tied to experimental use and 112 fixes and many other provisions that I think are probably just ladening the legislation down so that it won't pass. I think if people think that's the way to go, you need to look at what constituency groups are supporting what provisions and what congressmen, senators are supporting what provisions. And if no one is going to change their vote based upon a certain provision, like 112, maybe they should get rid of it. But I don't think the legislation is going anywhere. What I'm doing for my clients in drafting applications now is I go back to your earlier slide and I take the cases as they've been supported by patent eligibility from the Federal Circuit and try to mirror to the greatest extent possible my applications to the situations there. To the ones that are deemed to be eligible. And I also try to tell a story of a technological solution to a technological problem so that in the eventuality that something changes, my clients are supported. And I'm really not so concerned with the PTO because I think they're doing a fairly good job with the guidelines. It's my clients don't benefit if they can get a patent out of the PTO, but it's not enforceable in courts. So that's why I go for the mirroring. As I said, I don't think the legislation is going to go anywhere anytime soon, and I think we need to keep hammering the Court of Appeals for the Federal Circuit to come up with better decisions.
Yeah. So what I was just looking for here was, if I can see how quickly I can pivot here to do this, because I had written. Oh, it's not going to let me pivot.
I have defensive cases that I use: Digital Image Technologies, Caltech v. Hughes, Enfish, Bascom Global Internet, INRI TL Litigation, Macro v. Bandol, Thales v. VisionX, Recognizant Corp v. Nintendo, Visual Memory, FinGen, Berkheimer, and
Okay.
Cora. So
Yeah,
that's
and here's that's what I'm pushing right now. I wrote an article back at the beginning of the year in January called "The Key Lighthouse Cases."
Yes.
And this is what a lot of us look to is if you're looking at these cases like DDR, Enfish, Macro, Thales, FinJan, Core Wireless, and Cora, these are the cases that if the Federal Circuit is going to liken your claims and your innovation to them, you're going to be in a good place. If they're going to liken them to the other cases where they came out and it was not patent eligible, then you're going to be in a bad place. So this is the Lighthouse Cases. You can find that on IP Watchdog. If you go and just up in the top right corner, you search Lighthouse, it'll be the first thing that pops up. So so I agree with you 100%. Now, David, I want to get your advice on drafting the claims. So let me push this slide here for a minute. This is a Sola Tran, but I know you've got a slide specifically on claim drafting tips. Is it perhaps appropriate to push that one at the moment so we can talk about your tips in light of this claim in particular?
Sure, I'd be happy to. Yeah, go ahead and put that one up, and we can start talking about some of what actually I take that back. Put the Sola Tran case claim back up, because I want to make one quick point before we move forward on that.
Sure. So that should be, oh, I'm sorry. I'm acting like it's back up and it's not back up. It's back up on my screen.
Okay,
now I gotta put it back up on all of your screens. And of course, my GoToWebinar control panel is not cooperating. I've got the spinning wheel of death here. There you go.
So, and this really is it's a tip for the draftspeople. And I want to echo what Bob said, that getting it through the patent office is one thing. You want a claim that's going to be enforceable when you get to court, right? When you get in front of the Federal Circuit, you want them to bless the claim. And one of the things that jumped out at me when I read the case, you look at this claim. This is claim 1, and it's the broadest claim in the patent. And I wonder, why are they having a battle on 101 eligibility on the broadest claim of their patent? Do they not have a dependent claim that gives them a better eligibility position and still reads on the accused process? And it's one thing I want drafters to think about is whether or not you put some of this stuff in your independent claim, make sure you've got some dependent claims that help bolster that eligibility argument that you might face down the road. And maybe you don't need that to get through the patent office, but you might need it when you get to the Federal Circuit. And would this have been a different case if instead of arguing over claim 1, they were arguing over a dependent claim that had more in the case, more in the claim that really tied that inventive concept into a practical application? So that's just the larger observation of why is this battle even being fought on the battleground of claim 1 of this patent? And that's something that the draftsperson really could have helped the litigators out a lot by having some more in that patent that helps them out. So yeah, if you could go to the claim drafting tips slide.
There you go.
Okay, so the things I want to focus on, like I said, I mentioned earlier, you really want to focus when you're drafting the claims, keep these things in mind, the step 2A and step 2B of the Alice-Mayo test. And I think it's important, not just for the patent office, I think it's important when you get further down the road, but you really want to ask yourself when you're drafting the claim, have I in the claim demonstrated that this inventive concept has been integrated into a practical application? And that's of course prong 2 of step 2A, so that even if it's determined that the claim is directed to an abstract idea, if it's integrated into a practical application, then you go, you jump immediately to go and you bypass step 2B. You've got an eligible claim to work on. What does that really mean? Well, the patent examination guidelines tell the examiners to look at, does the claim actually impose a meaningful limitation on the inventive concept? You look at the Sola Tran claim, they have a comparison in there. They don't really ever do anything with a comparison. Are they really integrating this in? You want to think about step 2B too, as does the claim recite significantly more than the abstract idea? I think that's a little bit of a trap, and I think I'd stay away from that for some reasons we'll discuss in a bit, but really focus on integrating that inventive concept into a practical application. And when you do that, think about what's the difference between implementation and application. There's a lot of cases where the court looks at the implementation. They say, like, how are you doing this? So implementation is how are you doing whatever this, implementing this abstract idea is. Application is what do you do with it? What is the actual thing you're doing with that abstract idea? And a good example of it, if you go back to the Diamond versus Deere case, and that was the case where the claim was calculating the Arrhenius equation and then using the results of that to open a mold, right? So implementation would be calculating that Arrhenius equation using a computer, but that's not application. Application in that claim was using the results of that calculation to open a mold. And I think that's the key that made that allowable. So
almost like industrial versus digital.
Industrial versus digital.
And the way I get with that is sort of like the judges seem, they're older, they're much more comfortable with things that they're familiar with, right? So creating molded rubber tires has always been patentable. That's a patentable process. So the way that you've done that is always opening a mold and pouring stuff in, whether it's glass or whatever it may be. So just calculating how to do that in the time that might be needed is interesting, but calculating that and then having some kind of like robotic arm then open up the mold so that say like liquid glass pours into the mold, that's the complete process. That's a complete system.
Well, yeah, it's not that you're calculating something, it's that you're calculating something and doing something with it. And that's what's often missing from the claims. It's fine to do it, but it's what do you do with it? And I think that's not necessarily, I don't think it necessarily matters that opening a mold is a physical process and you need to have something like, that's that physical and tangible that the judges can really get their heads around. I think that same concept applies even in computer communication, wireless sort of technologies where you don't have something that's quite that tangible. But what they're looking for is not just that you're doing the calculation, it's what do you do with it? Like say for example, that your invention is a novel way of calculating beam forming weights for a phased array antenna, right? You might have a great new formula or great new approach for calculating that, but if the claim doesn't actually say using it somehow or doing something with it, then my guess is it's going to be looked at as really just trying to claim the idea. But the key in my view is what do you actually do with that? What is the application that you're doing? And that needs to be in the claims, somehow in the claims. And you have to write it obviously in a way that's still going to be a single actor. You don't want divided infringement. You want to make sure that it's covering the commercial embodiment that you want, that it's giving you the appropriate scope, but it needs to have something more than just the implementation. So it would be a difference between if I just claimed calculating the beam forming weights on a computer, that's not going to be enough. That's implementation. What we need is application. And there's some really good examples. I would point, this is on the slide here, I would point everybody to go look at examples 40 and 41 that were provided with the 2019 guidelines for a really good sort of example of how that plays out.
I like your analysis. I kind of agree with I think it's very good. My problem with it is that the courts have not adopted the guidelines, and that second prong of the first prong, the evaluate whether the judicial exception is integrated into a practical application, is part of the guidelines, which I would love to see that get adopted by the courts. And I actually think that's the case in Sola Tran, and yet the courts have differentiated again. So and remember, these claims were done a while ago, so they didn't have the benefit of our foresight. I still don't understand why Sola Tran is not patent eligible.
Yeah, I don't either. I have real problems with it because, it does seem like they're acting on it here. And I think what it is you run the risk with, and this may just be where we're at right now, is the things that you write, by the time they get evaluated and tested, they're going to be 8, 10, 12 years down the line.
Yeah.
And the way that you're doing it today is not the way you did it back then. And if only you used today's standards, you could have written this. And that really is unfortunate, because a lot of them, I shouldn't say all of them, because there's some of these cases that, the quote unquote invention was not an invention at all. And I think we could probably all agree with that. Like the one that always jumps to mind is Perfect Web, where they said just resend to your email list. I mean, that's not an invention. But these things that are falling, if you could write them today based on today's standards, they're innovations. They're being tested based on a standard that was not in place at the time. And when I look at this claim in Sola Tran, yeah, it's broad, but breadth is not a reason to say that it lacks under 101. I mean, maybe it's under 102 or 103
or 112.
Well, I don't know. Wait a minute. I don't know that breadth is a problem under 112 either.
Well,
I mean, it says what it says. That it captures a lot is not a problem as long as it's novel and not obvious.
True. What's really bothering me, though, is that the courts are not recognizing what they're doing to the American economy and to our job creation in the United States. And then investment money is not flowing into these areas the way it's been alleged to have been doing for a long, long time. And there doesn't seem to be any concern whatsoever that this is causing huge problems for innovation in the United States at all.
Right. So
not
now,
a factor.
To put a bow on this, because I think I don't, well, maybe Dave, I didn't tell you in advance I was going to ask you this, and I don't like to. So if you want to say no, that's perfectly fine, because I don't want to suggest it, and I'm already on record as saying I think that this claim should have survived. And I don't even know which firm or which attorney wrote this claim, and and I've had a claim fall at the federal circuit. So I want to be, but I also want to try and provide information here. Is there anything that could have been done based on today's standards? Not saying that what happened here was wrong, because I don't think it was, but what would you recommend if you're writing a claim like this today? What would people try?
Hang on, let me just pull up my copy of it here. So I agree with both of you that it's really, really hard to look at this claim and say, what could they really have done better? What I would do is take a step back. You realize that the people that are interpreting this claim are human beings, and human beings have a remarkable ability to make up their mind first and justify it later.
Yeah.
And I think that may be a lot of what we're seeing here. And so the question to me is, what could you have done to tweak this claim so that the first impression that whoever's looking at it gets is not, oh gosh, this is a really broad claim, I need to protect the American patent system by getting rid of it. But how could you make it better in terms of looking like it really is directed to a more concrete, tangible sort of invention? And what I would do if I was writing this today would be do a better job of tying these elements together. And so for an example, step A is electronically receiving this data file. that includes an amount of a transaction associated with MICR information for each paper check. And then B, after step A, crediting an account for the merchant. Well, what does that have to do with step A? Is that crediting the account in the amount of the transaction that was electronically received? I don't know, it's just standing there. You don't have these elements really tied together so that they integrate each of the elements together. And I think, is there something specific I could point to and say, yes, if you had included these words, the court would have come the other way? I don't think I can say that, but I think the claim would have given a better impression to the court that it really is something more than just trying to claim a broad abstract idea and cover it up with a bunch of words.
Yeah, and I like that advice a lot, and that's advice that I give attorneys a lot, is that particularly with that first claim, and who knows, this isn't the first claim likely that was filed at the patent office, but when I talk about drafting applications, I'm not a fan of the first claim being the broadest claim, because you want that first claim to be one that the examiner looks at and sees as something that's reasonable that they can work with. You don't want to be asking for the moon, the stars, the sun. Oh, and by the way, throw in the Milky Way galaxy while you're at it. That's just not reasonable. So I do like that advice, Bob. I mean, you started off as an examiner. You've been at the patent office for many years. It sets people on the wrong path when you start asking for way too much, even if you ultimately are entitled to it, I suppose.
Well,
right?
I still draft broader to narrower. But I don't claim what I'm not entitled to. I mean, that's the.
Right.
I don't want to tick off the examiner by overreaching. I want to press that boundary as much as possible. So I am going to go out there a little bit, but I'm not going to go crazy. And I think that's the way to handle it. And I would
Right.
also, like I keep saying, tell the story in your specification of how your invention is a technical solution to a technological problem. Tell the
Amen.
story.
Amen. And I think a lot of these problems are problems that we created ourselves by per se rules after KSR, and that we reacted to, oh my God, we can't say anything in this specification anymore because it may wind up being obvious. Well, guess what? We're not even getting to obviousness anymore.
Right.
And I get it. You can't say the wrong stuff, right? And you can't be stupid. Don't do stupid stuff. I get it. But if your invention is an innovation, I mean, look, we have the FinJan case, which was if on this list here, and I'll quickly throw up the list. The FinJan case, almost right in the middle from 2018. It was January 2018 versus Blue Coat. Judge Dyke wrote that decision in favor of the patent owner and said that FinJan pioneered that type of security protocol. And well, where does that come from? Well, it comes from the way the patent application was drafted. And that patent was a 6 million number patent. So obviously it was drafted the old style, right? And that really, the old style and the EnFish was an old style patent as well. And it's those old style software patents that when the courts look at them, that are winning the day, those ones. And then the other ones are the ones where clients are not necessarily trying to win a numbers game, but are giving their attorneys time to thoughtfully prepare a specification and to thoughtfully engage in prosecution. David, do you agree, disagree with anything I just said, and why?
No, I 100% agree, and I think there's a point that can be made to anybody that's looking at this from the in-house counsel perspective, and it's sort of a cautionary note to not set out rigid guidelines for your outside counsel to follow based on conventional wisdom, because that conventional wisdom can change, certainly changes over time. It can change in a heartbeat. And while you might set out guidelines that you want your outside counsel to follow that seem like they're absolutely reasonable in view of the current law, when that patent gets issued, it's going to sit out there for years and years, and it might not get tested until the law has changed substantially. And if your guidelines required every single one of your patents to be written in a certain way, and then the law changes to disfavor that, well, you've impaired the value of your entire portfolio. It's okay for different lawyers to take different approaches, And in fact, you want to encourage that, because that's what lets them explore new ways and better ways of doing this, and it gives you some some variety, and some diversity, for lack of a better word, in the way your portfolio is constructed.
Yeah, yeah. I mean, let's face it, these things are assets, right? So you don't want to put all your eggs in one basket, the same way that you're not putting your retirement all in one basket, hopefully, right? I mean, you see what happens when you do that. The people who did that and invested in Enron wound up not being very, very lucky, and so you got to diversify your portfolio. I think that is great advice. And I'm gonna steal that one, David. Because I think it is great advice. So now we're talking about this, David. Let me push the specification drafting tips so we don't lose this one, because I think once we start talking about Chamberlain, we may have a little bit of disagreement, and I don't want to lose this this slide. So you want to tell us what we're looking at here?
Well, the question is, well, what do you really need to do to make sure that you're supporting what you're doing with the claims? And first thing I do is I'd actually echo what Bob said as far as telling the story. You want to tell the story of the technical solution to the technical problem. Maybe that's a better way of saying it that I should have put on the slide there. But I at least have the bullet that you want to explain what those technical advantages of the invention are, and how that solution solves that problem. You want to try to focus on technical benefits, because that seems to please the courts a lot more than focusing on business benefits. Like, for instance, in the Sola Tran case, they talked about some of the purported benefits of the solution, and they were really business benefits, which can of course be very valuable and very important. But you want to try to focus on whether there's some sort of technical advantages to doing what you're doing that you can hang your hat on there. And sometimes you have to work creatively with the inventors to identify those things, but usually you can come up with something, particularly in the computer and wireless area. You talk about things like processing resources, memory usage, latency, network performance. Is there something about this that helps that? And really make sure that you've got that description in your specification. My first bullet is to use a top-down approach to describe the invention. This is something that we like to do when you describe the invention. I go back to my beamforming weights example. Your beamforming weights might be generated in a base station. They might be generated at a transceiver, at a satellite. You don't really know. But instead of just diving right into the processor and the signal processor that's doing the actual calculation, at least start with the product or the system that you're describing the invention in the context of, and then drill down with some figures into okay, we start at the system, and then we're going to go to the base transceiver station, and then within there we're going to go into this other subsystem, and then start talking about the invention, so that when the reader is reading what that benefit is, or what that invention is, they can place it into some kind of context that makes sense to them. And this is a criticism I actually have of the patent in the Chamberlain case that we can talk to in a little bit. And a lot of times when you work with the same clients and you deal with the technologies over and over again, those first few figures and description can all be reused, because you're generally focused on the same sort of things. It's not like you got to do a whole lot of new drafting to do that, but give the reader some idea of the context of the invention instead of diving right into the block diagram of the particular subsystem.
Yeah, I really agree with that a lot, and I've said many times that I think all patents have far too few drawings. Drawings are just worth their weight in gold for a variety of different reasons, and including in these software applications, because you really, I think, need to be looking at these as a system and the architecture that goes with that. And when I was trying to find a good portfolio to use to teach, that I could use as a reference point for new students to learn from, I looked at the Ring video doorbell, because you see those commercials all the time, and they have hundreds of patents, and they have drawings of everything, showing it from the user's perspective, showing it from the technology perspective, flow charts, everything. And I think that's the way that you have to do this today. I fundamentally think that if you're not doing it that way, you're not doing yourself any favors.
Well, I think it helps to psychologically condition the reader to understand that what you're claiming is a real thing or a real process in a real system. And if the first few things you look at are the actual system, then it's easier to kind of get yourself over that hump of thinking, okay, we're talking about something in the real world. If the first thing you see is just a block diagram and a flow chart, it's harder to tie that to something real. And I'm not saying that you can't do that, or that makes the patent invalid or anything, or that's impossible to get it through. But from the perspective of the person that's looking at this and trying to evaluate whether you're really just trying to cover some abstract idea, it helps. It helps. We found that it really helps to approach it from that perspective.
I agree. And for God's sake, a line is not a flow chart. A block to another block is not a flow chart. I mean, you got to have more than just that. I mean, how many of these applications, and Bob, I mean, how many of these patent applications in the software space do you see that have one or two drawings and it's a block connected to one block connected to another block? And that's it.
Too many, but sometimes you got to remember some of these things are going into other jurisdictions, and you do have to have stuff like that. Yeah.
Well, sure. And that's fine. I mean, if you want to have that, that's fine, but you can't only have that.
Right.
Right. I mean, so, but I interrupted you before you were getting to your practical application, I think, David.
Oh, I apologize. I'm not sure exactly where
okay, no, that's fine.
I can go back to the slide though. And keep,
no. That's fine, because I definitely want to get to Chamberlain here, and let me push, because I think I put these slides probably out of order. It's probably best to summarize this case first before we look at the claims. And this was the garage door opener case, and and Judge Chen was on this case again, and I think probably we all sort of have an idea of what he's saying, or what he's trying to say is that the wireless communication here is known to exist, so therefore that can't impart any novelty to the claim, so therefore is patent ineligible. Now that is so conflated, it's sort of odd to say it that way, but that's just the state of what 101 analysis is these days. The problem I had with what was going on here is on page 6, Judge Chen writes that the claim does overcome certain undesirable disadvantages from previous systems. And then on page 7, the very next page, found that it was somehow still nevertheless non-inventive. And that sort of becomes difficult to understand how, for purposes of 101, it could address disadvantages, so therefore it should be characterized as an improvement. And then on the very next page say it's not an improvement. And I thought the analysis was jumbled, and frankly I almost wondered whether this should have been a non-presidential opinion, because it's kind of read like it was written by a staff attorney or a clerk, because it didn't, the analysis here was not the type of analysis you would expect, or I would expect. It was internally inconsistent in places like that, which normally you do not see in presidential opinions, at least, but you do tend to see in non-presidential opinions. I won't necessarily ask you guys to comment on that. You can if you want, but I won't ask, but that's my observation. But what I found interesting here was
the problem here is this is a garage door opener with a transmitter on it. How do we ever get to patent ineligible? It's a garage door. I mean, this is just infuriating to me.
I know. Well, and what I also don't get, I mean, before we even get to that, I'm trying not to rant here, because I'm leaving the ranting to you, but I amen, by the way, brother. But the thing that was just bizarre here was, if you're going to compare it to the prior art, which they did, and they said, oh, we've compared it to the prior art, and the only thing that's different compared to the prior art is that it's wireless. Well, if you're going to do that, then why not leave it to 102 and 103?
Yep.
I just don't get it.
I don't either.
Gene, what the way I read this, what the court kind of pulled a fast one here. And what they did was they looked at the claim, and then they pulled out at a very high level of abstraction what they thought the abstract idea was as what they thought was really what was being claimed. And then they turned around and said, you're not allowed to look at the abstract idea when determining if the claim has got an inventive step. So if you take the abstract, if you pull the abstract idea out, and that abstract idea is really what defines the inventiveness of the claim, and then say you've got to find something else inventive in this claim for this to be eligible, yeah, you know, of course it fell. And I think that's the wrong way of looking at it. I think this all flows from a mistake that the Federal Circuit has been making, which is using the same kind of analysis for mathematical equations and laws of nature that they do for abstract ideas.
Yes.
If you look back at the Alice case, that one thing the court actually does a good job of in Alice is explaining why the judicial exceptions exist and what the harm of allowing people to claim the judicial exceptions are. And the court says something along the lines of, we don't want people to take these building blocks of innovation for themselves. And while that makes sense in the concept of a mathematical algorithm or a law of nature that in some sense exist independent of human discovery, and we don't want people to take those and appropriate them to themselves, it's a very different thing when you talk about an abstract idea that didn't exist until the inventor created it, until the inventor thought of it. And
Absolutely.
they're treating them the same.
Absolutely.
And that's what they did here.
And that is why I said earlier on, you know, that this, and let me see if I'll push the right slide. When I was doing my rant here, and I'm trying not to lose my temper, I'm trying not to turn red, but when I go through this statement that even if the idea is novel and not obvious, that's not enough to save it. That's idiotic. It's stupid. It's
the
ridiculous.
The sentence is illogical on its face, Gene.
It is, and that's
read
why.
The sentence, because
I know that's why I said in this article, and I took some crap from it, and I know that they've read it. I said it's impossible to believe that they could achieve an acceptable score on the LSAT because this is illogical. It's illogical on its face. You know, it doesn't make any sense. You can't have it that way. And the reason is that it would only conceivably make sense if you're talking about a true idea in the copyright sense. Like, oh, I want to write a novel on World War II. Okay, well, you know, you can't get a patent on that. You can't protect everyone. Well, why? Well, because you haven't told us anything about it other than just like the most basic concept, right? But we're not talking about that. And that's, you put your finger on it, David, exactly. They're using the same exact test with math, you know, and those things that are truly what we would call abstract ideas, and applying them to things that have a real tangible physicality to them. And it doesn't work that way. If it has a tangible physicality to it and it's novel and non-obvious, it has to be inventive, at least under step 2B. There's no other way. There's no other way. I'm sorry, I'm ranting now. I was going to leave this to you, Bob. Bob, do you have any thoughts?
It's a garage door, Gene. It's a garage door.
Well, wait a second though. Go look at the claim. Bring the claim
Let's
up.
Look at the claim.
I've got the claim. A movable barrier, operator comprising.
Where does it say garage door opener?
A movable barrier. It's a garage door, not a garage door opener. It's the door.
No, it's the operator. It's the garage door opener that we're talking about. And the thing that's funny about this, I went back and looked at the patent. So in this case, you've got a garage door opener manufacturer that's asserting this patent against garage door openers made by garage door opener manufacturer. Right. The claim never says garage door opener. The patent never says garage door opener.
See, and that's the problem. I mean, right there. I mean, can you please, if you're making something, can you at least protect what you're making?
I understand that, but it's still a movable barrier operator. I mean, it's a physical thing.
Right. No, I get it. I'm mad. I'm repeating myself 3 times. I'm really mad. Okay, so I'm mad at everybody. I'm mad at the Federal Circuit, for God's sake, because they damn well know what they're doing. And I'm mad at patent attorneys and agents who are trying to be too damn cute. You know why? Because now all of us have to live with the Chamberlain Group case. You know, all of us, because it doesn't need to be this way. It's a friggin' garage door opener, for God's sake.
Yeah.
A garage door opener. Call it a garage door opener. You know,
So
and this
would
is
it
what I'm
have hurt
begging
your
people to
infringement case
do
if they
is
called it a garage door opener?
I don't know, but I would really love, and I've been saying this for a long time, stop with, and I know this isn't a method claim, but in software, stop with the method claims. You know, we know what they think of the method claims. They hate them. And not only do they hate them, but what they do is they say, oh, your method claim is crap. And we know in your system claim, all you're doing is trying to claim the same thing that you claimed in your method claim. So therefore, your system claim is crap.
I
Call
don't
it
agree
a
with you on that
device.
one.
Well, I'm saying, okay, let me
Sometimes you
be,
need a method claim.
okay.
I mean, sometimes
I'm
I
not,
agree with Bob.
Jesus, stop. What I'm saying is, I swear to God, I pledged I wasn't going to get like this in this webinar because I'm really
love it.
mad.
I love it,
So
Gene. I counted on it.
okay, so what I'm trying to say here is keep your method claims siloed. Have the support and the spec for them, but keep them all in one patent, right? I mean, you can't contaminate patents. Like, to go back to David's point, right, is you have to have a diversification of your portfolio. You need to treat your patent portfolio the same way you treat your investment portfolio.
Agreed.
So have method claims in a patent. You can't have method and system claims in the same patent. I don't think. I think, and maybe have a patent that calls the thing a device. Go back to the 1970s when software was allegedly not patentable, and patent attorneys back then were just calling it a machine, right? And the machine just did certain things. Oh, well, how did the machine do that? Oh, wasn't the machine, because the machine is stupid. It was the software on the machine that made it do it. All right, I'm going to try and be quiet now. David, you're trying to get in.
Oh, yeah, you know, I agree with parts of what you're saying. I agree with Bob that keep the method claims in, even if it seems like method claims are disfavored right now. We don't know where things are going to go. And so I like to have lots of different statutory classes covered, and whether you do it in one patent or another patent, I think there's value to doing that, and I think it can pay off in ways you don't expect down the road. I think, while I share Bob's frustration about, this should never have been anywhere near the 101 radar, there are ways this claim could have been improved. The claim, when I read the claim, there's a problem. It reads more like a parts list to me. It's not connected. The pieces of the claim where you could point to and say they're inventive aren't integrated with the other case, or with the other parts, or with any kind of practical application. It talks about a transmitter that transmits a status condition signal. Who does it transmit it to? What does it transmit it for? What does the signal do? What is the application here? That's all missing from this claim. And like I say, I apologize. I'm not trying to Monday morning quarterback whoever did it, but we need to learn lessons from this, because we don't want our patents to get the same treatment. And I think a lot of this comes down to the first thing you look at is a movable barrier operator. Well, what the hell is that? And what's a movable barrier? Is it a port on a rapid thermal annealing chamber? Is it a bar that gets raised when you go into a parking garage? I don't know what that is. If you look at the patent, there's no picture of a garage door opener. All there is a block diagram. This is the problem that I mentioned before. It looks on its face very, very broad, very, very abstract. And what ties it together and what ties it to the application? You don't ever want to get to this point. You want to win your cases before they ever get to where they're being torn apart like this. And the last thing you want is for somebody to look at the claim and have their initial gut reaction to be, well, that just looks too broad. And
I hear you, David, but the claims are to be read in light of the specification. And while you're right, I'm not gonna say that this is the best claim that I've ever seen by a long shot. But what they're charging is that it's patent ineligible as it is, and I don't see that. I
agree that they're wrong. I agree that they're wrong, but we still have to learn lessons about how do we.
Absolutely.
Yeah.
You're right about that.
Hey, all right, we got a couple minutes left, guys. Let's see if we can get a couple questions in before I give you your final 30 seconds. Would descriptions of data structures be useful in the form of data storage if the data retrieval and overall speed of execution? So, I mean, my answer to that is if you have data structures, then you're looking at an more like being EnFish, and EnFish went well, and I think properly describing the data structures is only going to be helpful.
I agree with you.
Okay, so next question. Have your costs and prices increased for preparing patent applications based on these enhanced drafting tips and techniques? And if so, how are you addressing this with your clients? David.
Would somebody like to talk to my clients about the need for increasing the
Yeah.
you know, we constantly have pressures being put on us to do more with less. I think the best thing to do is get into the habit of incorporating these sort of habits into your drafting, and then they don't become so burdensome. Then it becomes just sort of a normal part of your process where you just instinctively put these things in there. As you get to know the technologies better and as you get to know the clients better, you will naturally start to put those things in there. I don't think we can do anything about the fact that there's always going to be more pressures put on us to do more of this stuff. I wish there was another answer.
I have another answer. I think my clients, the large companies, are very cognizant of the need for better quality patents and need for a more detailed specification that provides for a technological solution to a technological problem, and will pay higher prices for that. They're probably filing a few less patent applications and maybe not covering incremental improvements to the degree they did, but they are cognizant if their patent is to have value and if their portfolios have value, they need to have a better quality patent. And I think they're beginning to realize they need to pay a little bit more for a little more attention.
I think some clients are, and frankly, I think actually some of the smaller clients that are actually startups that have some funding get it more and react more. And you might expect that the smaller clients where you're closer to the decision makers might be more reachable on something like this. But the other thing too is, and maybe this comes from the shameless commerce division, but don't forget there's a lot of tools out there, and LexisNexis IP has a lot of tools that do help you streamline things, from this populated response for your office actions to their patent optimizer, which really helps you check your specification that you file to make sure that you're catching all the 112 issues. Because the 112 issues, that's where you're going to add a lot to your prosecution costs right there. And if you can do that, and because we know that we think we know that the patent office has to be using software to catch these 112 problems, right? Because the examiners have told us for years they don't even read the specification. And now all of a sudden over the last couple of years, we get 15, 18 pages of 112 rejections based on the spec. Well, where is that coming from? It's got to be software. So if they have software, then we should be using that too. So check out the LexisNexis IP suite of tools if you haven't already. Now, gentlemen, this has been fantastic. I really appreciate it. Both of you have been great, but our time is over, and I want to give each of you a chance to wrap up. Bob, I'll ask you first, and David, I'll ask you the same question. Bob, what is the one thing you want people really to leave remembering today?
Don't stop filing because the current law is not the way we want it. I think it will be changing. And if you have not filed your application, you've lost rights to it. So protect your innovations now and actively engage yourselves in trying to improve the system.
And David, the final word goes to you.
You know, I would say don't give up hope. Don't get too overly concerned about any one or two Federal Circuit decisions. Keep on focusing on the fundamental thing that the courts have always said that you can protect, which is the application of that idea. Focus on that application.
And that is great advice, you know, and I think the patent office is not going to get too focused on any one or two Federal Circuit cases. And by the time the cases you file today are examined, the law is going to be different. That we know for sure. So hang in there, get involved in the 101 debate on Capitol Hill if you can, because your participation will matter. So thank you for joining us today. Hopefully you'll join us again. We have more 101 discussions coming up later on this month. So check out IP Watchdog in our webinars area to sign up for webinars. And we have more LexisNexis webinars coming up later on this year. So we look forward to seeing you again. Until then, you guys have a great rest of your day.
You too.
All right.
Bye-bye.
Thanks.